session. Please be seated.
Good afternoon, everyone. Welcome. We have 3 cases on the docket, and we will hear them in the order in which they are listed. For the appellants, please remember when you come up and introduce yourselves. If you wish to reserve some time, let us know. You may reserve up to 5 minutes. I don't think there are any announcements. Seeing no one who wishes to announce anything, would you call the first case, please?
Brenda Smith doing business as Sugar Creek Carriages versus David Gerregano, Commissioner of the Tennessee Department of Revenue.
Morning, Your Honors.
Morning.
Good afternoon, I guess, sorry.
Well, yeah, that too.
Yeah, at this age. Gary Blackburn of the Nashville Bar, on behalf of the appellant, Ms. Smith, doing business as Sugar Creek Carriages, I'd like to reserve 3 minutes, please, for rebuttal.
3 minutes, all right.
This case, just telling a friend of mine, has the worst thing a client can have, interesting legal questions. Sugar Creek Carriages is a horse and mule-drawn carriage operation. They operate not entirely, but principally in downtown Nashville, going from the entertainment district all the way to the Bicentennial Mall. These are tours. There are some rare people who use it as transportation. It is a form of transportation that is amusing. They do tours in which they try to give some sort of historical insight on certain types of things. This is not a tour for the bridesmaids visitors. This is very different from that. Sugar Creek Carriages has its home operation in Hickman County. They have a farm. The carriages and the animals are transported to Davidson County by truck. There is an area in Davidson County that they use to stop and unload and change out the equipment, but no tickets are sold there, no rides are booked there. This case was brought originally on 2 bases. One was that the Department of Revenue has no authority under this taxing statute to impose a tax on a horse-drawn carriage company because there is no place of business here, and the statute requires that. And secondly, this is the only carriage company that has ever been taxed, and we wish to present evidence of having to do with a denial of equal protection, not selective enforcement. That would be a criminal concept, but a denial of equal protection by having individual entities treated differently, although they are not different. All these carriage operations essentially have the same form of business. This was...
Counsel, in your brief, you define place using Webster's dictionary as a noun that refers to a physical environment, a space. I wonder, why isn't the carriage itself a place? And you enter the carriage, you have a show put on for you of some kind, either somebody giving a guide in terms of the history or downtown sites, or a country musician that plays. Why isn't the carriage itself the place?
Well, I think because the context of that interpretation has to be the code, the statute. And this has to do with the interpretation of TCA 67-6-212A2. There are 4 subsections there, which both sides agree have the only application to this case is 1. And it authorizes the tax on the sale of tickets, fees, or other charges made for admission to or voluntary contributions made to places of amusement, sports, which we would say a natural interpretation would be places of sports, places of entertainment, places of exhibition, display, or other recreational events or activities. So in this context, we're talking about charging admission to a physical place.
But isn't the carriage itself a physical place? That's the question I'm
And you did say it was entertaining.
Well, some would find it entertaining, perhaps not some others, But
Not if
I
you're
would find-
behind it, maybe.
Yeah, it would amuse me. But the argument that the state made and that the panel discussed was, had to do with whether the statute permitted taxing the amusement itself as opposed to a place of amusement. And if you look at the statute, every indication we have here is that it has to do with physical locations. For example, the first one, Section 1, dues or fees to membership, sports, and recreational clubs, and so forth, including fees paid for the use of facilities or services rendered at a health spa or club. Those all suggest physical locations. Charges made for the privilege, this is number 3, of entering, engaging in recreational activity when no admission is charged spectators, such as tennis, racquetball, or handball courts, all physical places. And 4 is charges made for the privilege of using tangible personal property. One of the examples being trampolines, golf carts, bowling shoes. All of those things are rented at physical places. Now, if we are trying to interpret the word place, which obviously we can have other interpretations. There's, we're all familiar with a sense of place, for example. That has to do with other sort of concepts related to the definition of the word within context. However, in this instance, the law is clear, and the state does not argue this, that ambiguities are to be resolved in favor of the taxpayer, not in favor of the taxing authority. If there is an exception advanced, then the burden is upon the taxpayer to demonstrate his or her qualification for the exception. But we're talking about something that's never been done before. This is an effort to extend the taxing authority of the Department of Revenue beyond anything previously done or recognized.
The Missouri case that the lower court relied on viewed the area where the carriage or vehicle traveled as the place of amusement.
Well, it did. That was relied upon because no authority in Tennessee could be located by either side. But what that had to do with was use of the word control, their interpretation of the word control. So if you control where the carriage is going, then they said that means that it's a place. Respectfully, I think that's nonsense. I haven't found any other courts that have adopted that.
You found any other courts that have rejected that?
No, but then it doesn't control any Tennessee law. It's based on another statute from another state.
I understand, but sometimes you got to go with what you got.
Well, that's true, but what they have is nothing in Tennessee that trumps the presumption in favor of the taxpayer when you have any ambiguity. What they have done is usurp the authority, basically, of the General Assembly. The General Assembly has stated what can be taxed. They have referred to their own rules in which they are creating a previously unrecognized tax, and in so doing, they're referring to definitions in federal regulations.
Carol, hasn't the General Assembly authorized, though, the making of those rules precisely to fill in ambiguities and uncertainties that may arise under the statute?
Well, in some instances, Your Honor, yes. However, it is unlawful for an extension of authority to be made by regulation that is not previously found by the General Assembly. If the General Assembly wanted to tax mere amusements outside the context of place, it has that authority. If it wants to assign the authority to the Department of Revenue to decide whether to create a tax, then we're talking about another legal issue that's not before us, having to do with whether that violates separation of powers and whether it's appropriate for a legislative body to assign its function to a part of the executive branch. But here, no one until this case has ever advanced this theory having to do with horse-drawn carriages. So who is creating it? The General Assembly could have created it. They mentioned bowling shoes. They could mention horse-drawn carriages, and then I wouldn't be here. I might be here on another subject, but I wouldn't be here on that. That being the case, then is it correct that the Department of Revenue, by mere regulation, can create a taxing authority over a whole class of taxpayers, never done before and never specifically authorized by the General Assembly? The panel acknowledged the presumptions in favor of the taxpayer, but never applied them. We had the discussion, I mentioned this in the brief, they were defining place as not the carriage, they were defining place as where the carriage went. So one of the examples, I mentioned this in the brief, was the Ryman Auditorium. Well, the carriages go by the Ryman Auditorium, but they don't charge admission to it, and these taxes are charged against admissions. They also go by the Baptist Church and Masonic Lodge and the state capitol, but that doesn't transform the carriage into a place of amusement. The carriage is what it sounds like.
What's going on in the carriage? Is the driver giving a running commentary of everything they're going by, talking about the Ryman and the Capitol and whatever else they're driving by?
Yes, although that varies widely by the knowledge and temperament of the operator.
I'm sure it does. But well, isn't that entertainment?
It's entertainment, but that's not the distinction.
Yeah, but it's occurring in a place, either the carriage or the street.
Well, it is absolutely clear that the carriage is a form of transportation. That doesn't mean it can't be amusing, but it's a form of transportation. It's regulated.
Can it be both?
It can be both, but it is regulated by the Transportation Licensing Commission. You have to get a certificate of
Can't you
necessity.
be regulated by, you take a boat on the Mississippi River, it's regulated by those who regulate boats, and there's entertainment on it. There's all kinds of stuff going on those boats.
That's true. I'm not sure that would be a place of entertainment, place of amusement under this
I
statute.
think that's why people go there, isn't it?
They go there for the amusement, but they don't go to a place. The boat takes you to a place. It starts at a place and it winds up at a place. Now, there's also lots of
So
penalty
just,
issues.
if it moves, it can't be a place. Is that the theory?
I'm sure there can be exceptions, but yes, Your Honor, that would be the theory. Because a place has always been something where you go to the door and you pay a fee. The time is up here, but one of the cases cited under that statute has to do with this old place called the Ace of Clubs. I, of course, would never have gone to a place like that, but they would charge admission at the door.
Judge McBrayer can tell us about it.
Yes, they charge admission at the door, and part of it was going to the band, most of it was going to the band. Well, what that case stood for was that the admission goes to the owner, and that's what the taxes applied to.
Time's up. Thanks. General Lewis?
Thank you, Your Honor. May it please the Court, I am Larry Lewis from the Attorney General's Office representing the Commissioner of Revenue. Since 2000, Sugar Creek Carriages has provided rides primarily through the entertainment district of downtown Nashville on themed, decorated, horse-drawn carriages, or sometimes mule-drawn carriages. This case boils down to three considerations. Number one, is it a place? Number two, is it an amusement? And number three, has there been any sort of impermissible singling out or discrimination against Sugar Creek? We respectfully submit that the answers to those questions are yes, yes, and no in that order. Now, obviously, Sugar Creek does not own or control the entire entertainment district of downtown Nashville. But Sugar Creek's driver controls the route over which the carriage goes. That route is a place, and Sugar Creek charges admission to its customers to access that place on the carriage.
General, does it matter that it's not a set route, and it's not and if I recall the Missouri case correctly, it's point A to point B, and it consistently follows the same route? Here you have multiple alternative routes that you can take. Is that of consequence?
I think it actually makes ours an even stronger situation than the Missouri case. In the Missouri case, there were set routes. The driver still had some control over which route he took. Here, there are no set routes. Sugar Creek's drivers go wherever they want to on the occasion, depending on the wishes of the customers, the traffic patterns, the weather, whatever. So they have an even greater degree of control than in the Missouri case. But we would submit that the Missouri case, which is directly on point, both the statute and the facts are identical practically to our situation. We think our case is even stronger because the Sugar Creek's drivers do have complete control within the designated area of where the carriage goes. Sugar Creek charges admission to be in that place, and that's what the statute says. There's no need to worry about ambiguity here because what Sugar Creek does falls precisely within the language of the amusement tax
So
statute.
Surrey on the Plaza seems to indicate that the route itself is the place. And the court there relies a great deal on the fact that there was control by the company over that route. But going back to Judge Usman's question earlier, why wouldn't the carriage be the place here?
We don't have any problem with that approach, Your Honor. In a sense, the carriage could be a place. Our argument has been based on the other prong of the statute simply because we thought that was more direct and we did have the Missouri precedent. But I think you can certainly say that the carriage, especially when it is parked at the initiation of the ride and a person pays to get on the carriage, that is a place. We have no problem with that.
I mean, I keep thinking, can't a ride be an amusement and rides move?
An amusement.
Can a ride be an amusement and rides move? I mean, they move through the air, they move around an axle. I mean, they're not all of them are stationary. I'm thinking about the Supreme Court case from '85 that was cited in your brief, the Sky Transpo case.
Yes.
That involved the buckets. Now, I know that came out that it was transportation in that instance, but the dissent makes a very strong argument there that those are in fact amusements. They're not, they're just moving through the air from point A to point B.
Well, Sky Transpo looks at a number of different factors. And of course, that involved the gondola lift at the Knoxville World's Fair back in 1982. And there, the court, as you point out, Your Honor, in a 3-2 decision, decided it was more transportation than it was an amusement because, for instance, the fair workers actually used it all the time to get to where they needed to be on the other side of the fairgrounds. But here, the facts are very, we can look at those factors, but here the facts establish conclusively that this is primarily an amusement and not transportation. Of course, the carriage does move, and that's fine. You can have both. Just like in the Carson Creek case that the 3-judge panel below cited, there a campground was held to be within this amusement tax statute because, sure, it provided a place to stay, but the amusing part was predominant over the lodging part. Well, in this situation, it's perfectly clear that the amusing and entertaining part of these rides is predominant over the transportation part. And there are 3 things that make that inescapable. Number 1, these carriages don't go very far. The area within which they are restricted by the Metro Commission is like a mile square, as Mr. Blackburn has described, and so they're never over a mile or 2 from where they started. Number 2, there's no guarantee that you're going to get anywhere on one of these rides. If you have a destination and you ask the driver to take you there, he might do that, depending on his cooperation and the traffic and whatever. But they charge by time. And when your time runs out, Sugar Creek puts you out on the street regardless
That's
of where
the
you are.
unamusing part of the.
So, and sometimes the aggravating part, according to the deposition of Mrs. Smith. And then again, finally, as purely as transportation, the cost would be ridiculous. There are different carriages decorated in different ways. The cheapest and the most frequently used one is the Cinderella carriage, which charges $124.95 for a 30-minute narrated ride. The Surrey carriage, which is a large carriage, charges $304.95 per hour, or $500 for the special event first hour. Obviously, these are very steep charges for purely transportation when a taxi or a bus or a scooter or even walking are cheaper and much more reliable than one of the carriages.
The admission, General, that's being paid for in this case is admission to the carriage itself, right? You're not paying for admission to be in front of the Ryman. You're paying to be admitted to the carriage and wherever the carriage takes you. Now, you may have preferences in terms of I want to be in this spot or another, but I'm paying to be inside that carriage.
I'm willing to go with either theory, Your Honor. If they're paying for admission to the carriage when they get on it and it's in a place, that's within the statute. If they are paying for the route and to be on a sightseeing tour that takes you by the Ryman and the Capitol and the Bicentennial Mall and wherever else, that's within this statute too, because those are places, they're entertaining places, and I think that can be construed as falling within the statute. Actually, the amusement tax statute was intentionally written to be very broad, and we can see that by this discussion. And we have no problem with saying that the carriage is a place. We think that under Part 2 of 67.6.212, that's our primary argument, that the route of the carriage is a place. Part 3 talks about engaging in any kind of recreational activity. Well, that we could fit under that. And then Part 4 taxes charges made for the privilege of using tangible personal property, and includes golf carts. Well, a carriage is tangible personal property, and if a golf cart is in the statute, maybe carriages are too. So we think we get it several different ways. Another interesting point, Sugar Creek has criticized our use of the Standard Industrial Classification Manual and the items that are listed there as somehow expanding the scope of the statute. Our tax laws throughout rely on the Standard Industrial Classification Manual. And in particular, in pertaining to this case, if you look at TCA 67.6.102.86D in its present compilation, that's the definition of sale. And all of this turns on the meaning of sale in 212. But sale is described as not only charges for the privilege of having, for entering into places of amusement, or for the privilege of having access to amusement recreational facilities. Well, the carriage is certainly a facility, and that part of the language doesn't turn on place. And then it says, such establishments or facilities include but are not limited to the amusement and recreational facilities and motion picture theaters described in the Standard Industrial Classification Index prepared by the Bureau of the Budget of the federal government. So there is specific direct statutory authority for the department's rules to turn to that manual and use them. Now, we don't think that's really necessary here. It's illustrative, and it helps to point out specific applications of the statute. But the statute is intended to be broad, And we think we fit under it under all of these different ways.
General, even if it is taxable, there's still the issue here of the equal protection argument in this case. Sugar Creek is saying they're the only ones getting hit with this tax, and that violates equal protection. And the state's opposing that. And why isn't this a proper equal protection claim that's being advanced?
Well, it isn't a proper claim because, number one, they have not established that they are the only similar company being taxed. And number two, they have not established that there is any intentional discrimination on the part of the Department of Revenue. For them to prove an equal protection claim or a selective prosecution claim, it's all the same thing, they would have to show those things. Sugar Creek has tried to draw a distinction between selective prosecution and equal protection. That's all the same thing. The U.S. Supreme Court has said in the Armstrong case, U.S. versus Armstrong, that's cited in the briefs, the requirements for a selective prosecution claim draw on ordinary equal protection standards. They must show a discriminatory effect and a discriminatory purpose. And we have in this record shown neither of those.
How does a taxpayer get the information about selective prosecution of a tax in an instance like this? Because below the state relied on confidentiality provisions saying, well, we can't provide that information. So how does a taxpayer ever go about showing we're the only person getting taxed?
I think it has to depend on the circumstance, Your Honor. In this instance, there allegedly are 8 similar companies that Sugar Creek has listed by name. Well, those companies could have been deposed. Affidavits of the financial officials of those companies could have been put in the record. None of that has been done here. So the record is completely silent as to the taxation of these other companies. Sugar Creek submitted the declaration of Johnny Smith, but that's purely hearsay and not competent evidence. So it just depends on the circumstance. Here, the number is such that the supposedly 8 similar companies could have been investigated and deposed.
So, maybe they're the first. Maybe they're the first you've audited since you've decided to apply the statutes this way. That's not discriminatory, is it?
Of course
Somebody's
not,
got to
Your
go
Honor.
first.
We completely concur with that view. Even if they had been shown to be the only one that had been taxed, there's no hint in this record whatsoever of any impermissible purpose on the part of the Department of Revenue. And we don't say that impermissible purpose would have to be like a suspect class or something. I mean, it could be a personal vendetta, but there's no hint of that in this record. So we meet neither prong of the test that all the courts have applied to determine an equal protection violation in this area. And yes, revenue has the responsibility of trying to determine what is taxable from all the individuals and companies and events that happen in this state. I mean, that's a monumental task. They have to depend on the public's cooperation and responsible reporting by taxpayers who are liable. I mean, the census shows there are like 7 million people in Tennessee, plus thousands of businesses. So revenue has to enforce it as best they can through their audit process. And just because a company happens to have been audited doesn't mean anything as to the status of others. Maybe they're the next one on the list. Who knows? But revenue has to do what it can within its resources. So we submit that the decision should be affirmed.
Thank you, General.
Thank you.
Please the court, the defendant referred to the case by then Judge Koch, that name of which escapes me because they cited I didn't, but in which it was specifically held that in a selective enforcement context, you had to show the disparate classes and treatment of disparate classes. The problem with that is that that's a criminal context, and it's a subset of equal protection. The law seems clear that taxpayers generally have to be treated the same.
Counsel, to raise a class of one claim, not a suspect classification claim, but a class of one equal protection claim, which is what I take your client to be doing in this case, don't you have to assert some sort of basis for animus in terms of why your client is being targeted, that the state, maybe the Department of Revenue is just not competently doing its job of taxing, but don't they have to actually be setting out to try to engage in, based upon animus and differential treatment?
Well, I understand that point. I would respectfully submit that no, that's not required. You have to start with the disparate treatment and showing that the other members of the class are the same.
Okay, what's the disparate treatment? What's the proof of disparate treatment?
Well, I didn't mean disparate treatment in the context as an employment case of disparate treatment. I meant that I think it's absolutely clear that no other entity driving carriages in this state, which are almost remarkably similar, have ever been taxed.
How do we know that?
Well, we know that
Is it in the record?
Well, first of all, we weren't permitted to discover that because what the department did was they said first, because of this case, this is what you have to show. And then secondly, we asked them to admit that these other companies were not taxed. And they said, no, that falls within this statute that says we can't reveal any tax information.
Okay.
So they took the bat out of our hands and called us.
Did you take a survey?
Pardon?
Did you take a survey? Did you depose some of the other company heads? Did you ask them for affidavits? What's in the record that shows they don't pay?
The statements made and the request for admissions that we asked to be deemed admitted, it is correct we didn't do that. That would have been about a $10,000 task to do that. You're talking about Memphis, Chattanooga, Pigeon Forge. It would have been a Herculean task. And then you'd have to show that all of them weren't being tasked and some of them weren't willing to be cooperative.
I'm not sure you have to go quite that far. You just have to find a few that weren't taxed.
Well, but then there are distinctions between them. So we're told that you cannot ask us to admit the obvious, which is not about somebody being taxed, but about somebody that's not being taxed. By definition, if they're not being taxed, there is nothing to reveal except the fact.
Time's up.
Thank you.
Thank you. Thank you both. Very interesting and gives us much to think about. There goes the audience.